wish to take your lordships principally to some very interesting underlying juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the speaker. That's going to be the bulk of my argument. The very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. Well, this is a very unique and a strange case, and I would say from this side a sorry case, where lordships has double whammies and triple whammies. Let me explain how. My Lord Mullis put the question of the governor's role, and in one sentence the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trust vote, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock solid principle of interpretation of constitution and statutes is that if intentionally a constituent assembly in its amending power of the constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is as axiomatic. It is obvious a puny contract or a statute, much less a constitutional amendment, where your lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are at least two circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, the lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. In whatever way he's acting. Now, as the governor, most of all, is supposed to know the constitution. All of us are supposed to know the constitution, and ignorance of the law is no excuse, much less ignorance of the constitution. There is no system, and I'm not talking of your lordship's narrow question of trust vote, non-trust vote. There is no basis on which your lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. The two are irreconcilable, and that is a very major constitutional sin underlying this whole supposition and context. The second makes this even more bizarre. There is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking Lordship Justice Shah is right. We are not on appeal on that. That's not the point I'm arguing. I'm on the context, People are here going around merely on the assumption of a split, then the Lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? The second answer. Your Lordships decides cases, not that your Lordship decides the narrowest of narrow issue, your Lordship decides the whole context. But your Lordship doesn't decide beyond the context of a case. Your Lordship is very careful, otherwise the things of whiter and all that come in. And your Lordship doesn't have time to spend on hypothetical questions. But let us see the context. The context of this case can be divided into broadly three or four categories. And that context makes it clear that your Lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now that will be awaiting your Lordship's decision on nabab. So phase 1 or part 1 of this context is disabling notice. Your Lordship must decide in nabab. That's the whole argument we made for 2 days. But clearly the context is that step 1. And if that is wrong, then a lot of things fall down. And that is wrong in case your Lordship doesn't agree with the literal text of nabab. The second part is that we are also forgetting repeatedly the object of the 10th schedule. well as more than any other jurisprudence in this part, subject of constitutional law, are cases again and again talking of two things: the evil prior to 84, the object of plugging that evil, the mischief rule, and what your lordship is doing by the 10th schedule. The third is that if your lordships accept that the basic object of the 10th schedule is a constitutional sin being precluded or stopped or reduced, then 2-1 A or B, as the case may be, has to be decided first. It's logically prior to everything. Not only is it prior in terms of serial number, but conceptually it has to be logically prior to any decision of any kind in any case. I'm talking of concept. I'm not talking of a delay by an individual speaker. Whether the Kerala speaker will decide tomorrow, Nagaland speaker may take 6 months, a Manipur speaker will take, that's not the point. Conceptually, the logically prior decision has to be para 2, not a governor's intervention collaterally in any which way. That's the structure of the 10th schedule. And that scheme and structure must be endorsed and strengthened by your lordships. Inter alia, by not accepting any collateral incursion horizontally sideways by a governor, while that 2-1 is still pending. The fourth. Other aspect of this, which has to be given a lot of weight is, apart from what we just talked about, the trust vote, people tend to forget that in almost every assembly, there is a very interesting rule. You cannot bring repetitive no confidence motions also.
6 months.
Your lordship knows 6 months. So I bring a no confidence against you, I lose it, I can't come after next week again, say I have no confidence against you. So, the next facet of this is the processes within the parliament and assembly have to be allowed to work themselves out first before external intervention. And one of the important processes is to notify a confidence or a lack of confidence. If your lordship is so careful about not even allowing repetitive bites at the apple to destabilize a government, your lordship will allow an external incursion without even a single no confidence motion. I'm not repeating, I'm giving lordship in addition the larger context. Not even an attempt, as they say, the proof of the pudding is the eating. If you have the confidence, move the no confidence. It's your lack of confidence which makes you not move the no confidence. Because you know how the no confidence will be met. And may the best man win. If you have the guts and the courage, do it. Whoever will happen, will happen. That's the process of democracy on the floor. Incidentally, when I've done the maths, that chart, it is not that your lordship will only ask them to show the material. We are having a preliminary objection that the governor doesn't come into it irrespective of the material, even if he has seen the material. I am now on concept, I am on juristic principle. There is no role of the governor till now, till whatever I have said, 2-1, etc., process, no confidence, no role for the governor. It's a second separate question on facts, what the governor saw, did not see, but he had no locus to see or not to see. So what's the point of going into down that path, fellows? The governor had no locus at that stage to see or not to see. Well, it would really amount to a very strange thing where the governor would, governors are now, obviously, if you read the debates of Mr. Ambedkar and now there's a vast difference. But governors are also creatures of political connection. The governor would say, I see a group of people here. Why are you bothered about moving the no confidence? Come to me, we will see something. There's no need for us. The assembly gets substituted. You will be circumventing and short-circuiting the entire process of a no confidence on the floor. Yes. Now, brothers, having given that answer, let me turn to my larger point on which, brothers, I was really going to address your lordships. And give your lordship just bullet facets, and then I will, brothers, give your lordship the material underlying it, the juristic principles as to why your lordships should, brothers, deal with the matter here. Now, I understand, brothers, that it is easier not to deal with it here. It is also equally possible not to deal with it here. There is a speaker. My Lord has heard enough facts. So Lordship will take those facts as given. I will touch upon the facts here and there, but mostly no. In the event that the facts and the context suit your Lordship's discretion on this issue, should your Lordships in law juristically refer it or should you hear it is my respectful submission. Whereas there are four or five legal facets that I'll give you Lordship the case law. The first is, brothers, that there were two mullets, one negative and one positive order by this Honorable Supreme Court. That should be remembered. In whichever way, mullets, it is worded, the negative, I call it injunction, on 27/6/2022 was that by the expedient of extending time, the Speaker was effectively de facto could not pronounce on disqualification. It is nothing but an injunction in substance.
Till 12th.
Till 12th, correct. Then events took over, Malaz. Then events took over, but my Lord is right, till 12th. Therefore, Malaz, let us look at it because the Lordship is always a court of substance. We can camouflage in so many forms, but your Lordship ultimately sees this. In substance, it's a judicial injunctive interim relief qua a Speaker's future action under the 10th schedule. That is the correct way of putting it. It is, Malaz, a judicial interim intervention. It's a negative injunction. And the second was a positive injunction, if I may call it, or an order of 29th, allowing the trust vote to be held. So not injuncting the second day, injuncting the first day. So there is a negative judicial intervention followed by an affirmative judicial intervention. Well, I am not making any value judgment. Your Lordship would have heard it next week, 2 weeks later. Who knows, Maharaj, everything could have been reversed. I mean, I'm not saying that at all. I'm not saying right or wrong. But I'm saying one thing is clear, that the formation of a government, I'm making a neutral statement, I'm not allocating, is clearly the direct and inevitable result of the combination of these two orders. Your Lordship could have heard it next week and upheld it. So Lordship would be right. Your Lordship could have reversed it. Your Lordship would be wrong in the interim then. That's not the point. The point is, let us not see this case in the abstract in an ivory tower unrealistic approach. Let us see it in reality. We have to smell the constitutional coffee, if I may say so. The reality is this, that absent these two negative and positive orders, your Lordships cannot have this consequence of a change or a new government. This will have, correctly an effect on your Lordships needing to decide this year. Then, the second aspect, I'm only giving the legal bullets, I'll cite the case law later. The second legal aspect, the juristic principle is the language of that order. Now, we all say it casually. Sometimes your Lordship is also made to say it casually, but these are terms of art. Your Lordship has used them for decades and centuries in law. And these common law terms of art have to be given effect to. Don't go to the page, just note your Lordship's order on 29th read like this, one line, quote unquote, subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, unquote. Well, the first time your Lordship's ordered demolition, the first time, not now, of a 20-story structure was almost 15 years ago. Demolition, in that sense, with people living and concrete and mortar in the building, is much more irreversible than merely a political thicket or a scrambled political egg created from 22 to now. Now I come to what subject to means. The object of this phrase subject to are two and threefold. One is that your lordship's speaks in rem, not just bilaterally between the parties. Your lordship speaks to the whole system, to the whole world. And second, your lordship is giving a fair warning that everything which is happening after this is subject to, but on your risk and cost. And thirdly, your risk and cost means all consequences, equities, vested rights, all status quos you create each day after that. Is it your risk and cost? We are warning you. Don't blame us later. That's the meaning, Malas, of this, and I'll cite a case presently on that. Therefore, Malas, the moment, either lordship doesn't say it, the moment your lordship says that, no one can come and plead equities, vested rights, events, scrambled egg, irreversibility, etc., etc. Because your lordship takes into account this in advance. If your lordship passes subject to today, it is different from passing in 2022 June.